Okay, good afternoon, everybody. Welcome to the final session of our Clinical Cannabis Convention. Sorry about the coffee guy. I think they literally ran out of coffee. So everybody has been doing a very good job of the legal drugs around here today, so congratulations on that. Thankfully, no one will go to jail for doing double-shot espressos. So I'd like to start the introduction to the next guest, and I think I have to go back 30 years. I've been using the cannabis plant for over 30 years in various forms. And over those 30 years, I've seen many, many times how the plant can bring the right people together at just the right time. It's always some sort of synchronicity about this plant that brings the good people together at the right time. And when we first set off on this journey, the original advocate said, you are going to need lots of expert witnesses, and you're going to need some lawyers. You're going to need an advocate. You're going to need to make a big social campaign of all of this. And we met a historian who happens to be one of the experts in the trial of the plant in the Pretoria High Court, Craig Patterson, soon to be Dr. Craig Patterson at Rhodes University. And he hand-delivered this curious piece of this document. I'll never forget it. It was on pink paper. I don't know why, but it was a photocopy on pink paper. And I started to read this document, and a shiver ran down my spine, because it was the very first time that I'd ever read what I think about the cannabis plant and how we are persecuted as cannabis users and stigmatized for the last 30 years. And what this paper had done was articulate how prohibition is completely irrational and unconstitutional. And I was quite amazed that anybody had spent the time to actually write it down. And we filed it away, and we were given express instructions from Craig Patterson, the historian. Listen, this guy's just starting off in practice, and he doesn't want to get embroiled in cannabis and everything else, but here's his thesis, use it, don't use it. And we thought nothing of it. We filed it away with all the other stuff we're trying to create, and we're putting this trial together. We really were poking in the dark most of the time. So, fast forward a couple of years, and we're still trying to find the right lawyers in the right town to do the right thing for us. And Myrtle and I knocked on lots of doors and went to lots of boardroom meetings in very powerful lawyers' buildings and say, listen, this is what we want to do. And they sort of go, whoa. The Law Society granted us permission to form South Africa's first cannabis non-profit company. And we were told to go to a lawyer's company in Melrose Arch called Schindlers, Inc. So we went to the second floor. In fact, I know it was the first floor. We went to a small boardroom because we were new. We get to the small boardroom first. And some people came down with clipboards and things, and they started taking all the details. And it's a very complex thing, putting an NPO together for an illegal substance. But they helped us, and they helped us. And on the second and third occasion that we went to sign more dotted lines and things, they said, you know what, the guys on the fifth floor, they're cool people, and they really want to meet you. You're doing a great job. So these other lawyers filed in suits, and they sat down, and we shook hands. And they introduced them to me, and they said, hello, my name's Paul Michael. And wait a minute, how many people in South Africa are called Paul Michael? This was the name of the thesis in the pink piece of paper from a couple of years ago. This can't be the same guy. But it was. The man that wrote the thesis in his first year at Rhodes University as a law student. I had that piece of paper for the last 2 years. Now I'm standing in front of the author. Well, I was very surprised indeed. And there was another man in the building as well. He was a lot higher up the food chain, and he said, listen, you know what? You've impressed us so much. We're going to take you on, and we're going to help you as much as we possibly can, and we are going to try and steer you through the judiciary to get what you want. Because at that point, their only reason to take us on was to make sure that we didn't go to jail. Because remember, Myrtle and I are facing 12 years in jail for having what the tabloids say is 1.87 kilograms of cannabis worth R500,000. with a street value of. So we accepted Schindler's invitation, and they've been steering us all the way. And that was, I think, 4 years ago. And in that time, we've become very, very friendly and personal with these guys. They've steered our ship, and we've had our ups and downs, and we've had some shouting matches and disagreements along the way. But there's one man in particular that has articulated this whole thing so perfectly, and he's always there. He's on a WhatsApp, he's on a phone call. He's always there to help us out, and he keeps us going. If we walk into Schindler's and it's grim, then we're grim, because if they're grim, we have to be grim. But they're not. They're such positive people, and they're positive people for change. So I can't believe it's my job right now to introduce the author of the pink piece of paper, Mr. Paul Michael Keichel.
Good afternoon, and thank you for being here. I think now that all of us appreciate the need and desirability for expert witnesses of the caliber that you've just heard from, and the clarity that they can bring to a debate like this, we might as well bring in a lawyer to muddle it all up again. So, how this started was with a hypocrisy that dawned on me when I was sitting in a cannabis coffee shop in Amsterdam, enjoying myself quite thoroughly. Now, the hypocrisy is reasonably well articulated on the screen, and that's really that the decision makers in this process are often people who are not acquainted with the use of cannabis. These are people who have often misunderstood and exaggerated the harms. They speak in hyperbole. And often what we find is that the assumption of harm is something that goes unchallenged as we continue to assess and reconsider our policies. Now, of course, I've given you a personal anecdote from Amsterdam, where within a jurisdiction where my use of cannabis was legal. And of course, were that not so, I have very little doubt that our trial judge would hear about it first thing on Monday morning. So this idea starts brewing. This was at the end of matric, and I get into my first year, and we do our introduction to constitutional law. And we start learning some basic things, We start learning some basic things about constitutional law, and it's really just an introduction. And the first thing that's not on the slide is Section 1 of our Constitution, which says that the Republic of South Africa is one sovereign, democratic state founded on the following values. And in sub-A says human dignity, the achievement of equality, and the advancement of human rights and freedoms. We move on to Section 2 of the Constitution. The Constitution is the supreme law of the Republic. Law or conduct that is inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. There are many rights in the Bill of Rights. We have a fantastic Constitution. It is one of the most liberal and progressive constitutions in the world, and it is in fact studied the world over by law students and is used as an example world over. So we have many rights contained within the Bill of Rights. But I've chosen to focus on one, because if I were to focus on all of the rights that we allege have been infringed by cannabis prohibition, I'm not going to be able to keep within time. And that right is Section 9(1) of the Constitution, which says that everyone is equal before the law and has the right to equal protection and benefit of the law. The Constitution is a reasonably skeletal document. I say this because it is intended that the Constitution is given meaning through our courts, through our high courts, through our Supreme Court of Appeal, and ultimately through the Constitutional Court. The courts look at our Constitution and assess what the meat is to the skeleton. What do these rights actually mean? Now, Hodgson versus Lane was a Constitutional Court judgment which dealt with the interim constitution. At that stage, Section 8.1, which was the equivalent of today's Section 9.1. And this has come to be known as the Harkson test. And it says, in interpreting the Section 9.1 right to equality, we ask ourselves, does the provision differentiate between peoples or categories of people? I think we can reasonably answer that in the affirmative, especially in this context. We know that cannabis users are treated differently. They are stigmatized, they are sent to prison, they are expelled from schools, they lose their jobs. These are all consequences that do not befall other categories of people, similarly placed categories of people, tobacco, alcohol, sugar users, for example. So we would submit that we tick the first box. If so, does the differentiation bear a rational connection to a legitimate government purpose? There are two tests in that. The first one is the the legitimacy of the governmental purpose. Now, in a vacuum, it would seem reasonable to all of us that to minimize the harms, or the menaces, as they have been called, of drug use is a legitimate governmental purpose. But our constitutional jurisprudence does not allow us to assess these things in a vacuum. We always have to make use of comparators. So we then ask ourselves the question, when we compare the harms of cannabis use to, for example, tobacco and alcohol, can we simply fall back on the fact that harm alone, or the reduction of harm, is something that justifies criminal prohibition? And we would say no. Then we talk about a rational connection between the legitimate governmental purpose and the infringement of the right. Does prohibition achieve what it sets out to do? If we assume that it is legitimate to minimize the harms of drug use, are we achieving it? I'm not going to repeat all of these harm reduction strategies that have been spoken about, but I think we can be reasonably sure that we are in fact achieving the opposite. We then go on to the next quote. The state should not regulate in an arbitrary manner or manifest naked preferences. When we view these things holistically, we see that we are manifesting naked preferences. We are manifesting, or we are legislating and enacting legislation that manifestly prefers alcohol and tobacco users and the users of all uncountable other vices to cannabis and tobacco users, to cannabis users. But the point here, in this Principe van der Linde quote, is that the state is bound to function in a rational manner. I think you have heard that the golden thread throughout all of our previous speakers is that what we are doing presently, today, by criminally prohibiting cannabis and putting people into prison, is not rational. But what's very important about this is that it is not for us to tell the legislature what to do. That is not what the Constitutional Court is permitted to do, because we have a separation of powers. All that the Constitutional Court ultimately is empowered to do is to tell the legislature and government that what they are doing now is incorrect and unconstitutional. Thereafter, leave it to the legislature to decide upon the best way to fill the hole that you have created through an order of constitutional invalidity. And it was news to me, but very pleasant news to me, what was mentioned not moments ago, that the MCC is now considering an analysis of the sort that Professor David Nutt took us through earlier. The importance of what's on the screen, though, is that despite it not being for us to tell the legislature what to do, if you look at subpoint E under 36(1) of the Constitution, this being the limitation clause, this being the prism through which we have to assess all limitations on our entrenched constitutional rights, we see a test, which is to say, are there less restrictive means to achieve the purpose? Once again, I'm not going to take you through it, but I think we can reasonably conclude from what we've heard today that yes, there are less restrictive and in fact more effective means to achieving the reduction in the menaces associated with drug use, and specifically cannabis use in this instance. There is a reversal of onus. I'll go into the trial in a little bit more detail in a moment. But there is a reversal of onus. The Dagga couple and a very sick man, Mr. Clifford Thorpe, are the plaintiffs in this matter. In the normal course, the plaintiffs bear the onus of proving everything, of justifying the relief that they are claiming from the courts. In this instance, the Constitution, or the interpretation of the Constitution, has created a two-stage inquiry, which says that the Dagga couple and Mr. Thorpe only need to prove an infringement of their rights. Thereafter, the onus switches, and it becomes the onus of the state to justify the limitations that they have imposed on us. And from my personal perspective, after what I've heard today, I don't think that that's going to be a very easy task. The first case in which this came before our courts in our new constitutional dispensation was Prince versus President of the Law Society. Now, this is a very differentiable case because Mr. Prince, a practicing Rastafari, didn't ask for the drug laws to be struck out for the benefit of the whole population. Essentially what he asked was for an exemption. He said, your drug laws are fine, but leave the Rastafari alone. And I'm not going to take you through that, but that was ultimately rejected because the court is not in the business of preferring a minority portion of the population and making them exempt from certain laws. But there was a concession made in that. But because the concession was made, that a legitimate state objective was served, this wasn't an issue that was ventilated through the courts. This wasn't something that they had to grapple with. And this is exactly what we're going to be grappling with in our forthcoming trial, or the trial that's already started. So, as Jules mentioned, one day, I believe it was about 4 years ago, in walked Jules and Myrtle through our door, and I met them. Now, I'm not one to believe in destiny, but I certainly couldn't resist, having written that essay, not taking on the Dagga couple in their case. And here we find ourselves. So where are we in the trial? We are 1 week into the trial. We've had some interlocutory scuffles. The first scuffle related to whether or not the Dagga couple, through Fields of Green for All, were permitted to live stream the entirety of the trial. The state and the 8th defendant were vehemently opposed to that, and ultimately, after 2 days in court, the Honourable Judge decided that they were allowed to, and was on the brink of imposing conditions. Again, that wasn't suitable, so there was an application for leave to appeal that permission. And that application for leave to appeal was refused. Immediately, there was a petition to the Supreme Court of Appeal. But let's not get bogged down in that, because in the meantime, while the petition to the Supreme Court of Appeal would have suspended the order allowing the live streaming, fortunately, in stepped the liberal media, News 24, and Media 24 and the SABC, who are now live streaming. So we think that we're going to get started with the trial, but not so. There was then an interlocutory application to strike out all of the annexures to our expert reports on the basis of the allegation that they were entirely irrelevant to the issues at hand. Now, one of those reports was, for example, the HIV and pain study that you were taken through by Dr. Donald Abrams. Other studies were those that were cited by Professor David Nutt, his Lancet Scale of Harm study. But apparently, these are entirely irrelevant to the question of whether our present drug policy is rational. I think it's fair to predict that we won that interlocutory scuffle, and we now proceed to trial. So we've had Professor David Nutt take the stand. He is still under examination in chief, which means that we are leading him through the case. We're not leading him, we are asking him non-leading questions through the case, whereafter he will be cross-examined by the state, he will be cross-examined by the 8th defendant, and we will have the opportunity, should we so desire, to re-examine him. And that process will continue with each of our witnesses, and once we close our case, the state and the 8th defendant's witnesses will take the stand, and the same process will be followed with them. We also have a historian coming on as an expert witness. He will go back into the original justifications for prohibition. He will tell us that there was never a rational basis nor a scientific basis for prohibition. He will take us through how this was an essentially racist, colonialist justification, whereby it was not a war on drugs, but a war on that with which the colonial powers were not familiar. We will also bring in a criminologist who will go into harm reductions and whether the current prohibitory laws are achieving the ends that they say that they will achieve. We will speak to Tony Budden, our industrialist, and he will challenge the classification of the cannabis plant, the whole plant or any product thereof, as undesirable. And we will say that the very classification of the whole plant as undesirable is something that smacks of irrationality and nonsense, for that matter. We will also lead the evidence of a rehabilitationist who will talk about his experience on the ground and what addiction really is, and what cannabis addiction really is, for that matter. And of course, amongst others, we really were desirous of leading the evidence of Dr. Donald Abrams. But as matters have turned out, the consequences of the interlocutory scuffles are that we just simply ran out of time. And as the good doctor told you, he needs to fly back to San Francisco this evening. But if we have it our way, we will have him back. And he will testify, and he will tell the court all that which he told you today. The opposition hold a very different view to us. And that's not to say that throughout the course of this trial, there isn't the potential for more agreement. But the way that we really view the polarization of this debate is that our opposition, the state and the 8th defendant, are of the opinion that harms in and of themselves are a justification for prohibition. They have not bothered themselves with the comparative harms of legal and illegal drugs. They have not bothered themselves with the benefits associated with the cannabis plant. But we hope, as I said again, that there might be a meeting of minds as this plays out. Ultimately, we hope for a judgment in our favor. Our next speaker, Advocate Mahon, is unfortunately not permitted to speak to you about the case. But I encourage you, at the end of this all, to tune into his closing arguments, because that will be where all of the evidence comes together, and the question is answered as to whether our current drug policy is rational. The case has to go on appeal. This is not within the hands of the parties. An order of constitutional invalidity has to be confirmed by the Constitutional Court in order to be effective. Given the nature of this case, I think it's very likely that we will skip the Supreme Court of Appeal and go straight to the Constitutional Court. Once again, it's not for us to tell the legislature how to fill the hole, should we achieve an order of constitutional invalidity. But when we have answered questions such as whether we have less restrictive, more effective means to achieve this purpose, and we have answered questions such as whether the current prohibitory regime is rational, one would hope that the legislature, in filling this hole, takes a certain amount of guidance from what is contained in the judgment of the High Court sitting in Pretoria. Finally, ladies and gentlemen, what are the prospects of our success? I will leave you today to be the judge of that on the basis of the strengths and weaknesses that you perceive in the arguments that have been put forth by our previous speakers. But from our perspective, we certainly hope that rationality wins the day. Thank you very much.
Thank you, Paul Michael. Thanks for that eloquent sort of explanation of the legal issues behind the trial.